Hello everyone, and welcome to another interview of the ICLID Center. Today our guest is Professor Thomas Cheng. Thomas is Associate Professor at the University of Hong Kong Faculty of Law, where he mainly specializes in antitrust. He is an authority in competition law pretty much across the globe. Indeed, he has worked and or studied in a number of universities in the United States, Europe, and in Asia too. And he is here today to talk about his last book on competition law in developing countries. This book can seem daunting at first because of its size. It's more than 600 pages. But I have to say that while reading it, I realized that its fluent and flowing prose make it a much easier read. But more importantly, this book is an invaluable source of information as it tackles a number of fundamental issues spanning from the relationship between competition and growth to IP and competition, but also industrial policy and foreign direct investment, among the many other topics that it covers. But probably even more importantly, it challenges an assumption that has probably led to the relatively scarce research in this area, which is that legal transplant and replicating what developed jurisdictions have done in the past render new studies, if not superfluous, perhaps not as useful as someone may believe. So this book, by contrast, as I said before, proposes the application of a tailored approach, a tailored regulatory framework for developing countries. And in order to do so, it provides the tools to policymakers and antitrust enforcers rather than proposing ad hoc solutions for specific jurisdictions. So, Thomas, in a time when everyone seems to be talking about competition law in the digital economy, you write a book on competition law and development. Can you tell us a little bit more about how you came up with this idea and this research focus?
Right, thank you, Claudio, for having me, and it's my honor to speak to you and to introduce to the audience my book. The interface between competition law and economic developments is a long-term interest of mine, and for those of you who are a bit familiar with my work, you know that this is not the first time I've written about competition law in developing countries. Interestingly enough, I first became interested in the topic because of my interest in competition law in mainland China, being the big next door neighbor to me. So I became interested in the issue of how competition law interacts with economic developments, how competition law enforcement may promote economic development and growth. But as I thought more about the mainland, I realized it really is an exception rather than the rule as far as the developing country is concerned. It's really not a typical developing country. And so I remain interested in the mainland, but I have moved beyond the mainland to become interested in developing countries in general, the more mainstream developing countries such as Latin America and Sub-Saharan Africa. And you mentioned this idea of, I guess my skepticism about convergence in general, and I've written about that before. And it's a long-held belief of mine that an area of economic law like competition law must take into account the local socioeconomic circumstances. The law does not exist in a vacuum, and you cannot apply the law that's fashioned in a completely different economic environment to another country. Adjustments need to be made. But here, it was quite tricky when I wrote the book because I didn't want to suggest that you need to change competition law wholesale. You need to make it something completely different. And I also was quite careful not to advocate or to be seen to be advocating using competition law as a development tool, because quite early on I became aware that I did spend quite a bit of time to study development economics, the literature on economic growth and economic development when in writing this book, and it quickly became obvious to me that economic development is a vast topic, and competition is just a very, very small piece of it. And if you were interested in economic development if you were a development economist coming from that perspective, competition or competition law probably would not be one of the first things you would pay attention to. It probably would not even be one of the second things you would pay attention to. But because we come from a competition law perspective, and we want to think about how competition law needs to be adapted in the developing country context, that's why it makes sense for me to look at the contribution of the relationship between competition law and economic growth and development, and see how it all fits in. And it was a mammoth undertaking. I believe about a month ago, I finally moved all the books I read for this book back to my office. And I think there were about 50, 60 books in addition to hundreds of articles, because it's just such a vast topic. And obviously a lot of people have written about competition law in developing countries. Eleanor Fox, Mikhail Gal, Bill Kovacic, Fred Jenny, a lot of superstars in our field have written about it, and I'm by no means the first person to do it. But as I started to do research on the topic, I realized there are a lot of works that cover different aspects of the issue, but no one has approached this topic, has tried to address the topic in a comprehensive manner. Examining the topic from first principles, which is, does competition and competition law enforcement contribute to economic growth and development? And beyond that, to move on to how developing countries should enforce competition law. And as I said, a lot of people have written about different aspects of the topic, but no one has really done it in an exhaustive manner. So that's why I decided I'll give it a try. It probably was a bit foolish for me to try to tackle such an ambitious project as my first book. It took years to do, but I guess when I finally finished it, I thought, oh, wow, actually, I did say something interesting, and hopefully something new in a number of areas as well. But yeah, so that's how I came upon this topic. I mean, I've been interested in competition and development, for more than a decade. And interesting you mentioned digital economy, because after I finished the first manuscript, I did wonder, should I add something about digital economy in the book? Because that's what everyone talks about these days. But then I realized, well, my book is not really about that. I mean, there are plenty of other people who are much more qualified to talk about digital economy than I. And I also don't pretend to have expertise on the extent to which digital economy, the technology has been adopted in different developing countries. And the extent to which digital economy issues would be relevant for developing countries, I guess, would very much depend on the extent of adoption of the technology. And I think it would be quite hard to write a book about this topic in general when China, it is a developing country, I guess, but obviously, digital economy is everywhere. In many ways, China is even more advanced than the US in terms of digital economy. The degree of digitization in China is probably even more advanced than the US, whereas you have sub-Saharan Africa when that is not the case. So it's probably quite hard to address digital economy issues in a book about developing countries. So I decided to leave it out. But yes, so that's how I came to the topic.
Wonderful. And I have to confirm that from my point of view, it was a successful endeavor. I'm still reading it, and probably I will do for years ahead, because it's a book that that, as I said before, for me is a very good read, but at the same time is one of those sources of information that you can consult every time you are dealing with a specific topic. So I found it very useful also for some of the papers that I'm working on, multiple projects, and coming from and researching from a developing country, I find it a very precious source of information. So I can confirm definitely that. That then, before you mentioned exactly the problem of the debate better around convergence and divergence and harmonization of competition law. And from this perspective, in your book, you dismiss the possibility of analyzing specific countries, for instance, through case studies, or better, you have a couple of case studies in particular on Japan and South Korea, but they are limited to the chapter on industrial policy and competition law. But from this perspective, you say that there is no universal approach to competition law. Thus rebuking the call for convergence of regulatory system that has been issued by many authorities, both in the academic sector and at the enforcement level. Now, how do you articulate the analysis of competition law for developing countries without treating them as a monolith? And what do you mean when you say that the book is for the proponents of an approach of informed divergence?
Actually, it's interesting you picked on this, because every time I tell people I'm writing a book on competition law in developing countries, the next question, and I'm not exaggerating, 95% of the time is which ones? And it's the first question that comes to people's mind, and I guess it makes sense. And but very early on, I realized, I mean, how many case studies can you do? And I mean, I know China quite well, and I know China better than probably most people outside of China. But I'm never going to know, say, Brazil better than a Brazilian competition law scholar. And for me, I mean, there are a number of reasons why I decided against a case study approach. First of all, in the space of a few hundred pages, how many case studies can you do? And you're always bound to leave out some relevant examples. And also, once you pick case studies, you get into the debates of, have you picked the representative ones? Why did you pick this case? Why did you pick that case? Why did you not pick this one? And it's an endless debate, and I don't think it really suits my purpose. And also, as I mentioned, I mean, say if I pick Brazil for one reason or another, I'm never going to know Brazil better than a Brazilian competition law scholar. And it just seems to me that, I mean, trying to spend time to learn about, say, 5-6 countries well enough to be able to write case studies is not the most efficient way to tackle the issues, because I believe that it would be a much more fruitful exercise to tackle the issues on a theoretical level, on a thematic level. Economic growth and economic development and industrial policy. I think there are a number of thematic issues that resonate across all developing countries. And as I mentioned in the book, in the end, I chose the approach, I'll address all the thematic and theoretical issues that I think could be relevant to developing countries. I'll let them decide for themselves which ones are in fact relevant for them. So I have a chapter on the economic the special characteristics of developing economies, and I believe I have about 10, 12 characteristics. I have prevalence of informal economy, prevalence of corruption, small domestic markets, missing financial institutions, etc., etc. I mean, while I believe most of them are relevant to most developing countries, I don't pretend to say that they are relevant to all of them. In light of these characteristics, I then propose some adjustments to competition law doctrines in the second half of the book on practical applications. And I just decided I'll tell people this is the adjustment I think should be made in light of, say, poor financial markets. For example, I say in predatory pricing, we, at least in the US, we often assume that, we believe that recoupment is important because even existing competitors have been driven out of the market. If new entrants can come in and challenge the monopolist and force the monopolist to lower prices and force the monopolist in failing to recoup its losses, then consumers are not harmed. That whole story presumes a fairly high level of market dynamism, which I think is absent in a lot of developing countries. I don't take the position that none of the developing countries possess the requisite level of market dynamism in order for the US insight to apply. But I'll just say that if you don't have that level of market dynamism, then you may want to be cautious about adopting the US approach, and then you decide for yourself whether you have that level of market dynamism. And I think it's a much more sensible approach. I examine the theoretical issues on a general level. I make suggestions based on what I perceive to be the characteristics of developing country economies, and I let individual countries decide whether these adaptations are relevant or called for their countries. You mentioned Japan and Korea, and you're right, actually. The book did have 2 case studies, and to the extent there were case studies in the book, the discussion about Japan and Korea's experience with industrial policy probably come closest to it. That was, again, also a conscious decision, because I think it's hard to evaluate the effectiveness of industrial policy in the abstract without looking at concrete examples. Whether industrial policy works, you have to look at countries where it has worked and see if you can replicate the success. And I originally also was going to cover Taiwan, because I believe Japan, Korea, and Taiwan are probably the 3 most successful practitioners of industrial policy. But that chapter was already 80 pages long by the time I finished it. And if I include Taiwan as well, it would be 100 pages, and OUP probably would have killed me. So I decided to leave out Taiwan in the end. And I think Japan and Korea were probably slightly more successful practitioners of industrial policy, or at least, I should say they were better known examples of success stories of industrial policy than Taiwan. So yes, so I decided I'll pick 2 successful examples and examine what they did, how industrial policy worked, if industrial policy was successful, and whether other developing countries have a realistic chance of replicating their success. Yes, so in that chapter, I did actually undertake 2 case studies, but those are the only 2 case studies you can find in the book. In the last half of the book on practical applications, it's full of examples. It's full of examples on, say, when I talk about the role of public interest considerations in merger review, for example, I talked about the public interest exception in South Africa. I talked about cartel enforcement in sub-Saharan Africa and Latin America. I mean, the second half of the book on practical applications is full of examples from individual countries. I want to examine what different countries have done. But I mean, they are not really case studies as such, because they don't focus on one particular country in particular and examine that country at length. I only call upon examples as they are relevant. But so, I mean, the book is not completely devoid of examples, and but yes, but I mean, not case studies.
Okay, so would it be correct to say that the approach of informed divergence that you propose would be mainly based on a careful study of your book by policymakers and antitrust enforcers that then at their turn can develop their own policies?
I mean, so I guess the first premise of my book is that competition policy as an area of economic policy in a developing country must have at its center a focus on economic growth and development. I mean, the basic premise of the book is that every area of economic policy in a developing country must be geared towards economic growth and development, because growth and development are too important to developing countries for them to ignore in any area of economic policy making. I mean, obviously, developed countries also have to grow. Economic growth is not a concern unique to developing countries. So to the extent my book examines how competition law enforcement can contribute to growth, it would be relevant to developed countries as well. I mean, there's quite a substantial discussion on how competition law can promote economic development. And by that, I mean poverty alleviation and satisfaction of basic development needs. Those I would think probably are more relevant to developing countries. And I mean, to the extent, I mean, I don't think, for example, the US and the EU need to enforce the competition law with particular focus on satisfying, I mean, popular needs for access to food and medicine and education, which I think are very important for developing countries. And so, I mean, I guess to the extent I argue that developing countries should pay more attention to satisfying their development needs, I'm arguing for informed divergence for sure. And also, as I mentioned earlier, there's a whole chapter on the economic characteristics, special characteristics of developing economies. And I mean, I then suggest adaptations to existing competition law doctrines in light of those characteristics. And I mean, obviously, that exercise is entirely about informed divergence, about adapting approaches from developed jurisdictions such as the US and the EU to the developing country context. But yes, as I mentioned, I have written an article expressing my skepticism about convergence before. I guess I'm not going to lie about it. I don't believe in convergence of competition. I mean, wholesale, unqualified convergence of competition law across all jurisdictions, regardless of their level of economic development and economic circumstances. I mean, that I definitely do not believe in. And I mean, I don't think every developing country, I don't think developing countries should reinvent the wheel and do it completely differently. I mean, if you read my book, I don't think I argue for wholesale repeal of the existing approaches in the US and the EU. The adjustments that I suggest are probably more tinkering in the margins, slight adjustments, but nonetheless important ones. And so, yes, so that's how I approached it in the book. And yes, I do believe in informed divergences. I mean, for example, in the book, I don't think, I mean, I never argue that we should adopt completely different rules for cartels, for example. I didn't say we should accept efficiency defenses in cartels. No, I mean, I think cartels are bad everywhere. But there are other areas of competition law doctrines which I think could be adjusted and should be adjusted in light of the special characteristics of developing countries.
Yeah, I believe that the paper that you were referring to before was Convergence and its Discontents, a reconsideration of the merits of convergence of global competition law, isn't it?
Yeah, exactly.
Okay, perfect. So who's listening to us can go and refer to that paper too. And I have to say that while consulting competition authorities in the developing world, I have to say that I have realized also another problem that you actually touch upon. You mentioned in your book, which is the creation of redundancies in the law due to mindless transplants. So what I realized is that sometimes when laws are transplanted that way, very often there are parts of the law that are not used just because they are counterproductive in that specific jurisdiction. So they are in the law, but they are not applied, enforced, not even interpreted in a way that might fit the local jurisdiction because it's almost impossible, which creates, for me, a counterproductive environment because even lawyers do not believe anymore in the law, which is a very dangerous situation from my perspective. And this is something that I realized only by living in these jurisdictions. And this should make, this proposition of creating more tailored approaches even more valid. But before by talking about this informed divergence, you mentioned a number of different goals of competition law. And we know that clear objectives, clear competition law objectives guide the enforcement of competition law, help to prioritize cases, and lead to an overall consistent competition policy agenda. However, quite often it is hard to determine the goals of a country's competition law. Sometimes they are not stated or they are not interpreted by the courts sufficiently. Do you think that developing country should expressly define its competition law and policy goals, or leave them to free interpretation, if any, of the court, administrative authority, and scholars? And are these objectives, are there objectives that should be preferred to others?
Interesting question. Before I address that question, I should also mention one further dimension which may necessitate informed divergences of competition law is, of course, enforcement capacity. Highly complex rules, effects-based analysis, free-for-all rule of reason analysis. I mean, it's really just not realistic for a lot of developing country authorities. It's just way too complicated for them. And so in the second half of my book, in making suggestions for how developing countries should adapt approaches from the developed jurisdictions to their own situation, in many instances, I suggest different approaches to developing countries based on their existing enforcement capacity. I mean, and here is another situation where I can't do a case study and I can't say, okay, Brazil, you should do this. Namibia, you should do that, because I'm not in a position to assess every country's authorities' enforcement capacity. But what the approach I adopted in the end, and I thought that was really the only sensible approach I could take, is to roughly classify countries into developing countries into low, medium, high levels of enforcement capacity, and make suggestions on if you believe you are a low level low enforcement capacity authority what you should do. If you believe you have medium level of capacity, what you should do, and let the countries themselves decide what they should do. And I mean, it's by necessity a very rough approach, but I mean, I don't think you can really. I mean, first of all, it's impossible to assess the enforcement capacity of every country's authority, and I don't think you can really, in a very strict manner, draw a correlation between enforcement capacity and the design of doctrines. But at the same time, I realized that I need to take into account enforcement capacity, because that obviously is one of the biggest dimensions along which a developed country and a developing country differ in competition law enforcement. So that was also what I addressed in the book. But to go back to your question about objectives, and yes, I mean, I guess going back to Robert Bork and the Chicago School scholars, they've said competition law doesn't make sense without a clearly articulated objective. And they, of course, believe that economic efficiency and consumer welfare should be the only objectives of competition law. I think having clear objectives help. I do agree with them, and I don't often agree with the Chicago School scholars, but I think in this instance, I do agree with them that it helps to have clearly articulated objectives. Otherwise, I mean, I think we all know competition law doctrines can be applied so differently if you have different policy objectives. I mean, a doctrine that focuses on economic efficiency versus protection of small and medium-sized enterprises versus consumer welfare could be very different. But as to what objectives developing countries should have for their laws, I mean, I think at the end of the day, competition law should be about protecting, promoting competition and protecting consumer welfare. I think you can't get away from those. But I don't think they should be the only objectives. As I said, I believe one of the main objectives of any area of economic policy in a developing country is to promote economic growth and to promote economic development, to help satisfy development needs. So I obviously believe that growth and development are important objectives for competition law enforcement in developing countries as well. I mean, as to beyond that, do I believe there should be other objectives? There could be other objectives. I don't have very strong views. I mean, I think I think at the end of the day, it's individual countries' choice what objectives they ascribe to their laws. I mean, any additional objectives they do ascribe to their laws hopefully are only secondary objectives, not primary ones. And because otherwise, I think one of the greatest difficulties with having multiple objectives is what do you do when they conflict? And I mean, there is the dreaded word of balancing. But how do you balance? What exactly do you balance? How do you balance when you're balancing something that are completely incommensurate? And that was one of the difficulties in my book as well, which is, I think I wrote the book under the assumption that competition law generally is mainly focused on promoting competition and protecting consumer welfare. But to the extent possible, competition law should also take into account development concerns and its impact on the poor. And but these objectives, I mean, protection of consumer welfare and promotion of competition on the one hand, and reduction of poverty and pursuit of development needs on the other hand, may conflict. And if they do, then what do I do? And I mean, the easy answer to give is, oh, you balance, and that's what you do. But I spent quite a bit of time looking at the existing literature on what do you do when you have conflicting objectives and the balancing approach. I mean, quite a bit has been written on it. And in the end, I just came away thinking, you can't balance. I mean, they are incommensurate things. And once you start going down this path of balancing against different objectives, it becomes very arbitrary. And so in the end, I came up with a slightly different a different method to tackle the issue. And in this instance, and again, this is probably one of the very few times I agree with the late Justice Antonin Scalia from the US Supreme Court, but I do think he's right when he says that a multi-factor balancing test just doesn't work. It's whatever the judge wants to decide, whatever the judge wants to say, because there's just no rigor and no rhyme or reason to how the balancing is done under a multi-factor balancing test. And I believe if you have conflicting objectives, that is always going to be one of the most difficult things. But to go back to your question, I do believe that there should be clearly articulated objectives in the competition law of developing countries. And I think the primary objective should be to promote competition and to protect consumer welfare. But there should also be a focus on promoting growth and promoting economic development and poverty alleviation. I think those must be there. Beyond that, if I don't have strong views about whether a developing country would want to add on some secondary objectives, such as protecting the environment. And I mean, those are very important things as well. I don't think they should be overriding objectives. I don't think they should be tiebreakers, but to the extent we can pay some attention, some regard to these objectives in enforcement, I'm not entirely against it. But to me, the difficulty once we go down this path is what do we do when different objectives conflict?
Yeah, that's a long discussed issue. That I have to say that Judge Scalia wasn't wrong when he said that balancing really gives an enormous discretionary power to the judge, and judges know about balancing only within the framework of the Constitution mainly. So they have to usually balance between different constitutional rights. And actually, there have been who has tried by. Lately, there was a paper by Judge Tizzano who wrote about competition law within the constitutional framework. He wasn't advocating exactly for balancing, but he was mentioning that issue too. And yet, it would be extremely difficult, even given all the past experiences of judges balancing between different constitutional rights. There are some competition law authorities that try to somehow give an economic value to different rights and to different conflicting interests, and yet probably we don't have enough experience. But yeah, I'm still very much interested though, and I'm looking forward to further research on this topic. Perhaps in the future, we will some antitrust authorities, will come up with a better idea on how to compare pears with apples, and who knows, maybe at some point we will get there. And now what I was also kind of wondering is, I correct me if I'm wrong, in your book you don't really advocate for using poverty alleviation as a shield, or better to create new block exemption, for example, to allow, for example, SMEs to get together and create cartels. But rather you use poverty alleviation to create exceptions in competition laws, but mostly as a sword, to be used as a sword. So, for example, if a dominant undertaking doesn't create necessarily a market distortion, but abuses its dominance by by creating a harm to the poorest or to SMEs owned by the poorest in the country. In that case, competition law should be used. Am I wrong or am I right?
Yes, I mean, that essentially is what I argue. And so in the book, I call it the harm avoidance principle, and harm being harm to the poor in developing countries. And so, I mean, this goes back to our early discussion about balancing different interests. And if you have a situation where poverty concerns conflict with competition concerns, protection of consumer welfare conflicts with poverty concerns, then what should we do? As I said, we could balance whatever that is supposed to mean. But after thinking long and hard about this, I decided maybe the best way to do it, I mean, I guess the only to me at the time, maybe I would change my views eventually as I do more and more research on this. But at least when I wrote the book at the time, the only principled way I could think of to address this situation of conflicting objectives is to have one trump the other in narrowly conscribed circumstances so that you don't balance. And so that's what I try to do in the end. And because I believe that, the absolute poor or even the moderate poor in developing countries really should not have their welfare further reduced to the extent possible. I mean, they're already doing very, very poor as it is, surviving on $1.5 US a day. Can they really take further reduction in their welfare? And so I believe that avoiding harm to the poor, I mean, further reduction in their welfare should be the paramount goal as far as promoting economic development is concerned. And so, the principle I fashioned is to the extent competition law concerns and poverty concerns conflict with each other, in the sense that enforcement of competition law under a pure protection of consumer welfare approach would harm the welfare of the very poor in developing countries, then competition law should yield. So, to me, that avoids the need to balance, because I've set out a very narrow, circumscribed situation where one trumps the other, you don't balance. But I was also very careful to keep the exception, the circumstance under which development concerns trump competition law enforcement very narrow, because otherwise, the exception would eat up the rule. But so yes, so in the book I argued it's only when the welfare of the very poor will be harmed by competition enforcement should we allow poverty concerns to trump competition law policy considerations. For example, as you mentioned, if yes, an abuse of dominance would harm SMEs run by the very poor in developing countries, even though they may not strictly harm consumer welfare. I think we should protect SMEs in that instance, because standing idly by would mean some very, very poor people being driven out of business and perhaps going hungry or even worse. And I think to me, I think it's very difficult to countenance that kind of policy stance in a developing country where, a substantial part of the population is starving and living in absolute poverty. But I think that is the only circumstance in which I would allow development concerns to trump competition law, conventional competition law enforcement. But so that's how I dealt with the issue of the need to balance against conflicting objectives. Otherwise I try to avoid having the need to balance. But that is the one instance where I think I cannot avoid a conflict between the different objectives which I think are important to competition law enforcement in developing countries, and how to reconcile the conflict.
Okay, let's change completely topic and go to one of your chapters that is devoted to intellectual property and competition. So when discussed the interface between these two, you utilize the concept of laggard innovation. Can you tell us a little bit more about its role, so the role of the concept of laggard innovation in shaping national and international competition policies?
Yes, actually. So the concept actually didn't exactly arise in the context of my thinking about the intellectual property and competition interface. So when I wrote the book, I decided I wanted to engage with the huge body of economic literature on growth. Economists have written tens of articles. There is a huge body of literature on growth in economics. And we talk about competition law enforcement in developing countries, how it can be done to promote growth and development. But Dina Weikat is really the one exception I can think of who has discussed this body of literature on economic growth in her work on competition law enforcement in developing countries. But otherwise, we as competition law scholars have paid scant attention to this body of literature. And so when I started writing this book, I decided, you know what, I'm going to do it properly. I'm going to spend a lot of time to study this vast body of literature to see what economists tell us promote growth, and whether competition and competition law development, competition law enforcement promote growth. And as I started reading article after article on the various growth models, economists have proposed numerous growth models, starting from the 40s to recent years. The growth models have gone through multiple generations, and but apart from the early ones on which emphasize the importance of investments, the growth models of more recent vintage all come back to the same theme, which is productivity growth and innovation. And the difference between the two is not always very clear. What counts as innovation? What counts as productivity growth? But these are the two things that economists keep coming back to. So the idea is that productivity growth and innovation, and productivity growth could be the consequence of innovation, is the key to economic growth. The idea is to do more, to produce more with the same amount of resources. That's what productivity growth and innovation ultimately mean. To produce more and to produce better with the same amount of resources. And so innovation is key in a lot of these growth models, but understandably, in a lot of these growth models, the innovation that is being discussed is innovation in the developed country context. And we're talking about, I mean, I call this frontier innovation. I mean, cutting edge innovation along the global technological frontier. I mean, genuine leading innovation in a global sense. I mean, of course, that's the kind of innovation that propels growth in developed jurisdictions, such as the US and EU. And so for those countries, that's the kind of innovation they need. But for developing countries, innovation still promotes growth, but it's quite obvious to me that we cannot expect developing countries to produce frontier innovation. We cannot expect developing countries to, I mean, some could, but the vast majority of developing countries are not in a position to produce frontier innovation, cutting edge innovation along the global technological frontier. But developing countries nonetheless grow if they have more innovation. Their economic growth also benefits from more innovation. So it became clear to me that a different kind of innovation has to be what promotes growth in developing countries. And so that's how I came upon the idea of laggard innovation. So I spent time reading about the kind of innovation that happens in developing countries and what kind of innovation will help to improve the technological capacity of developing countries. And I thought of a number of ways. And so, I mean, first of all, economists distinguish between product innovation and process innovation. And product innovation is what we usually think of as when we talk about innovation. And so with creating a new product such as an iPhone, 5G, an autonomous self-driving car, et cetera, a process innovation is a better process to produce the same thing. And developing countries, a lot, I mean, the more advanced ones are generally engaged in manufacturing. I mean, China being a prime example, but Southeast Asia, India, a lot of developing countries are engaged in manufacturing. And I think the more you're actually doing a manufacturing, the better position you are to come up with better ways to produce things. And so, I mean, to me, to the extent developing countries can come up with genuine innovation, I think is more likely to be of the process kind as opposed to the product kind. So that's why I thought, okay, process innovation must be one of them. And the second kind of innovation, I mean, to call it innovation is probably slightly, to some people, ironic, but imitation. Developing countries can improve their technological capacity by imitating technologies from developed jurisdictions. And the reason I call it, I include it under the umbrella of laggard innovation because imitation also requires R&D. Imitation is not easy. I mean, try telling, say, Bangladesh to try to imitate producing an iPhone. I mean, the amount of R&D required for a country like Bangladesh to be able to even replicate an iPhone would be enormous. And so imitation itself is very R&D intensive. It improves a developing country's innovation capacity, technological capacity, and it should count as innovation, local innovation as far as the developing country is concerned. And the last kind of laggard innovation I came upon was what I call in the book acquisition of tacit knowledge. And this is mostly relevant because in the context of technological adaptation. So when a developing country imports technology from a developed jurisdiction, a brand new technology, the technology recipient needs to adapt and localize the technology. For example, I mean, I once came across an engineer from Germany, and he works for a company that manufactures machinery that produces plastics. He was passing through Hong Kong on his way to China, and he tells me that he had just spent 8 months in a factory in the mainland to teach the local engineers how to use the machine. And I asked him, so why does it take so long? I mean, 8 months to use how to use a machine? I mean, really? And he said, yes, it takes that long to adapt and localize a technology, because a machine that works in Germany in that way may not necessarily work in the same way in the mainland, with different workers, different skill level of workers, different factories set up, et cetera, and to make a foreign technology work in a local environment, you need to adapt it. And one of the key components in the adaptation is to acquire what is called tacit knowledge by economists, which is how to use things, how to apply something. And so to me, acquisition of tacit knowledge in the context of technological adaptation, imitation, and process innovation are the three main kinds of laggard innovation. And developing countries, especially for those that do not have the capacity to produce genuine frontier innovation on the global level, should focus on those three kinds of innovation. And so to me, the question of whether competition and competition law enforcements promote economic growth in developing countries become the question of whether competition and competition law enforcements promote acquisition of tacit knowledge, imitation, and process innovation. So laggard innovation is, to me, the link between competition and competition law enforcement on the one hand, and economic growth on the other hand, in the context of developing countries, just like genuine global innovation is the link between competition and growth in developed jurisdictions.
Okay, perfect. So now to change again topic, in your book, you also talk about the relationship between foreign investment and competition law. Here we know that a solid regulatory environment that bestows a primary role to the rule of law is a good catalyst for foreign investment. On the other hand, too much competition, especially in small jurisdictions, may hold off potential investors. Finally, foreign investment, while introducing new resources and technologies in a country, may create economic dependence and slow down innovation. How do you untie this difficult knot in your book?
Yes. So one part of the book deals with the very difficult issue of FDI. And does competition and competition law enforcement promote FDI? Does too much competition deter FDI? Should competition law enforcement be dialed back in order to not deter FDI? And as as I thought about this issue and consulted the literature on the role between the rule of law and the regulatory environment and foreign direct investment, one word keeps coming up, and that's China. And a lot of these economists, I'm by no means the first person to examine the relationship between the quality of the regulatory environment and FDI. And it often arises in the context of IPR protection. Does a low level of IPR protection deter FDI? Does a high level of IPR protection attract FDI? A lot of scholars argue that in theory it should. And a lot of scholars acknowledge that, yes, perhaps in theory it should. But a lot of scholars also keep coming back to the fact that China probably did not rank very high in terms of the quality of regulatory environments and rule of law in the 90s, and I mean in the 80s and 90s, and perhaps even in part of the noughties. But nonetheless, it was the largest recipient of FDI among developing countries for decades. And so this led a lot of economists to question how important is regulatory environment really. And I am sympathetic to these economists and to these commentators, and I believe that at the end, quality of regulatory environment helps to some extent, but at the end of the day, FDI is an economic decision, and ultimately, the size of the market, the profitability of foreign direct investments matters more than the quality of the regulatory environment. If foreign investors think they can still make enough money for the investment to pay, despite the poor regulatory environment, they are still going to invest anyway. So I think quality of regulatory environment does matter to some extent, but I don't think it is the determinative factor. And I think if the underlying economics work, foreign investors are going to invest despite the poor regulatory environment. They'll just do their best to navigate the regulatory environment, or they will just impute a discount to their returns based on the poor regulatory environment. There's some literature on the relationship between competition law enforcement and FDI, and I believe the literature generally believes that the literature generally suggests that the relationship is probably inconclusive. But I think more importantly, some scholars have questioned, well, if foreign direct investment, if a foreign investor is only willing to invest in a country because the country's competition law allows the investor to cartelize and or abuse its dominance, is this the kind of investment we really want? Is this kind of investment really going to redound benefits to the local economy? Not to mention there's a whole body of literature that argues that the benefits of FDI to the local economy are often overstated. Enclave operation is a very well-documented problem. In a lot of developing countries, the MNCs invest in this enclave. Basically, the components come in from the port, get transported to the local subsidiary in an enclave, and then gets assembled and then gets shipped out. It creates very little benefit to the local economy. It doesn't source input from the local manufacturers. There's no technology transfer to local competitors or local suppliers. And it's really just one part of the global supply chain that is detached from the local economy. So basically, after consulting this, vast body of literature on FDI, I came to the conclusion regulatory environments is probably not the decisive factor in where the FDI comes in. Even if FDI comes in, it is not always beneficial to the local economy. And in any case, even if the local regulatory environment is a relevant consideration, competition law is probably a very small part of the consideration for a potential investor. I think, for example, tax laws, probably IPR, and the level of corruption, general governance quality, these probably matter more than competition law enforcement. And lastly, I do agree with those scholars who argue that if you need to allow a foreign investor to cartelize or abuse its dominance in order to attract the investments, do we really want it? And I agree, probably not. So in the end, I came to the conclusion that FDI should not be a very important consideration in designing the the competition law enforcement regime in developing countries.
Okay, thank you very much. And this was my last question. Thanks very much again for being with us, for accepting our invitation. It was a great honor and a pleasure to have you here. This was far from being an exhaustive interview about your book, but hopefully it was a taster. There were a number of hints, at least, about your book, which again, there will be more information about your book in the description below this video. So who is interested can definitely delve into this long but incredibly interesting read that is your book, again, Competition Law in Developing Countries, published by Oxford University Press. Thank you very much again, Professor Thomas Cheng. It was a great pleasure again to have you here, and hope to see you soon.
Thank you very much, Claudio. In 6 questions, you have hit the most important things in my book. Well done.
Thank you so much.
Thank you. Thank you. Okay, bye-bye.
Bye.